Morning, Sir James.
Are you online and happy?
I'm online and happy, but is the live streaming working? It says so, but you know.
Someone will shout if not, I suppose.
Let's assume it is. On we go.
My lord, I was still on the basic question of what is the proper approach for the appellate court to follow, and I wanted just to finish that bit, if I may. We've got a fair bit of ground to cover, but if I can finish that bit. I made the point yesterday by reference to the paragraph 14 of our skeleton argument that although, of course, I accept that some of these cases were commented on by Lord Reed in the abortion services case, there was quite a long and consistent line of authority prior to that that appeared to state the general proposition that in cases where the appellate court is considering proportionality, the correct approach was the traditional one of examining whether the lower court got the matter wrong. And I wanted to take you to one other case before coming directly to abortion services. I made reference yesterday to the Friends of Antique Cultural Treasures case, which my Lord Justice Singh will remember, particularly paragraph 6, I think it was, of that case, in which that traditional approach was the one that was applied. That's at tab 36. I don't invite you to turn it up now. Paragraph 6, setting out the correct approach. It was Sir Terence Etherton, my Lord, and Lord Justice Green, from recollection. Paragraph 6 is at page 1703 for your note, applying that very directly to the question of how the appellate court approaches proportionality. I wanted to go back in time, if I may, to another of the Supreme Court cases that was the subject of consideration, or some consideration, by Lord Reed in abortion services, and that's In Re B. That is behind tab 25, and it starts at page 1250. And you will see from paragraph 35 in the judgment of Lord Wilson on page 1265, the question that the court is specifically addressing and considering. I'm rather hoping that there will be a sideline section, sidelining paragraphs 35, 36 and 37. And can I just invite you to cast an eye down those 3 paragraphs, if I may.
Yeah.
So you'll see they're addressing the matter on a rather wider basis there, which is what is the significance of the fact that the HRA in section 6 makes, as it does, an appellate court a public authority. Is there anything, therefore, in the convention, is the particular question they're addressing, Lord Wilson is addressing in those paragraphs, is there anything in the convention itself that would dictate that an appellate domestic court must apply a greater intensity of review? And the answer that they give, correctly I respectfully submit, is a resounding no. You will remember that Lord Bingham, I think it was in the Belmarsh case, considered part of that, and I think there's a reference to it in Lord Reed's judgment in abortion services. One needs to exercise a little caution with that, because Lord Bingham's statement of principle was very much about how a domestic court at first instance should go about reviewing proportionality, and he was essentially considering in that case, as you will recall, the difference between, on the one hand, a pure rationality approach, and on the other hand, the greater intensity of review that is required by the proportionality analysis. Now, that's a point that applies as a matter of basic domestic court approach. It does not address the question which is being addressed here by Lord Wilson, which is whether or not there is anything in the Convention itself which requires the appellate court under a domestic scheme, it could be here or in France or Italy or anywhere else, whether that applies there. And my lords will well remember at least some of the peripheral backdrop to that set of issues, because there is a line of case law, as you'll recall very well from Strasbourg, Bryan and the United Kingdom and all that line, where a first instance body, use the word deliberately, often an administrative decision maker, does not satisfy all the prerequisites of Article 6 for the purpose of a fair determination of civil rights and obligations. And in those circumstances, you have a different question, which is whether or not a quasi-appellate body, as it were, the first time you hit court, often the administrative court, needs to do more. But that, again, is a different set of issues. And we respectfully submit, therefore, that basic analysis of Lord Wilson is and appears to be correct, at least in relation to that issue. Maybe a separate question about whether this case can be dismissed as establishing a general proposition because it's about care proceedings, but we'll come to that when we go to abortion services. But at least those paragraphs we respectfully submit are correct and well established on clear Supreme Court authority. And I wanted to go to two other bits of this case just before coming directly to abortion services. You will see in paragraph 37 on page 1266 that Lord Wilson refers to paragraphs 83 to 90 of Lord Neuberger's judgment. But before going to those, can I travel via paragraphs 45 and 46, still in Lord Wilson's judgment? Where he addresses the question, well, what is the right test if it isn't driven by the Human Rights Act? And he comes to the view that it's in effect, it's the wrong, in inverted commas, test that is set out in the CPR. You see that about between D and D on page 1270 in paragraph 46, with the preceding reasoning in 45. So note that that was the ultimate conclusion that he reaches. And then Lord Neuberger's analysis, 83 to 90, if you go forward there, it's quite a long section, but he essentially reaches the same conclusion. You see the title above paragraph 80, the appellate court's approach. And they're addressing this at the level of principle. There's nothing in the reasoning in any of these paragraphs which suggests that the reasoning is driven by or restricted to the context of care proceedings. They were asked to address the big point of principle, and they did so. And Lord Neuberger agrees essentially with the reasoning of Lord Wilson. See in particular paragraph 86. Relying on the CPR at paragraph 87. Rejecting the argument that the Convention or the 1998 Human Rights Act requires the Court of Appeal to form its own view, where a trial judge's decision on proportionality is challenged in paragraph 90. I should have picked up one other passage in Lord Wilson's judgment. Sorry to jump around, apologies. Paragraph 41, could you just go back to that, where there's a citation from Piglowska and Piglowski in paragraph 41, but I want the quote from Lord Hoffman. this is really to illustrate the potential difficulty of distinguishing between fact, inference, evaluation, and all of that. It's a pretty well-known passage, but I remind you of that. So as I say, that looked like a pretty clear authority from the effectively the Supreme Court in that context. Addressing the point.
Sorry to interrupt.
I'm so sorry.
If I may respectfully say so, it seemed to me to be pretty clear guidance from the Supreme Court, which is why when I was sitting in the Divisional Court in Shvidler, we applied...
You applied this?
But we were wrong to do so.
Well...
According to the majority.
And the problem, Sir James, is that in paragraphs 28 and following, I may have got the paragraphs wrong, I think it's a bit earlier than that, 25 and following in abortion services,
Shall we go there?
is explained.
Well, yes. Query, query. Should we go there? Tab 44, 1994. I'm not allowed to accuse the Supreme Court of not explaining things with the greatest clarity, but the paragraphs aren't entirely clear, I respect this.
It's not for us to say.
No, but, well, again, no query. I mean, the difficulty that you may face is...
Well, you urge us to say so, do you?
Well, I don't urge you to say that there's anything wrong with abortion services, but I am going to urge you to take a pretty cautious approach to treating abortion services, establishing a general point of principle, which says that you need to start intervening and making effectively de novo judgments about proportionality yourself.
Well, I mean, it may help if I just tell you the way I'm thinking about it. The first thing this court has to decide is whether the court below applied the right test.
Yes.
And I think it is possibly said against you that Mr. Justice Garnham did not. I'm not sure it's quite so clearly said that Sir Ross Cranston did not, but it is in certain specific respects said he did not.
Yeah.
But let's assume for the purpose of this debate that they did apply the right test.
Yes.
The legal test.
Yes.
That then arises for consideration on what basis the court can review, the appellate court can review their assessment of the 4 tests of proportionality.
Yes.
And it seems to me at the moment anyway that that can happen if the appellate court thinks that the evaluation was looked wrong, but that it may be different, as my lord indicated really yesterday, if the evaluation that has been undertaken is something like a care order or something very factual or a divisional court, an extradition case. These are things completely beyond my ken. But if it's very factual, and somewhere in abortion services, the Lord Reed says, what I'm talking about is where, on a judicial review, the facts are taken and not really contested, which is the common case. The facts are laid out, there isn't any cross-examination. I think we said in the gender dysphoria case that it just isn't open to you to say you just reject out of hand the decision maker's explanation of the facts unless you've made that very clear in advance that that's what you're trying to achieve. Then there might be different procedures that are followed. So the situation may vary when you're reviewing a proportionality decision, depending upon whether you're reviewing a decision where the lower court has had contested facts and decided contested facts or not.
Yeah.
But in a normal judicial review situation, which is what Lord Reed is talking about, I would take some persuading at the moment that he's not talking about a judicial review of a policy, a judicial review of a rule, or a judicial review of a decision. because it seems to me it would be bizarre to have a different test applicable to different things.
Well, then let me seek to persuade you. Because
No,
I don't
no, that's what I wanted to be clear, because I wanted you to persuade us.
My lord, my submission, as you know, starts. We give you the argument of principle and we'll come to the paragraphs. You've obviously read the paragraphs, we can decide what but it starts from the proposition of various issues of principle as to the correct approach being set out in the CPR. Is there a difference between the approach that is to be adopted when you're considering proportionality or not, addressed in a succession of Supreme Court authorities, to some extent distinguished or not in abortion services, query how far they go in relation to that. And the real issue between us, I suspect, is whether or not you can simply say, as my lord has summarised it, that judicial review traditionally starts from a position where you're not dealing with much contest on the facts, and it's all about the evaluation of the criteria. And if you're in that territory, which will almost always be the case, then it is open season in the appellate court for it to adopt, in effect, its own de novo approach to that evaluation. You can effectively reprise, in a proportionality case, what the first instance judge did, as long only as that there aren't contested facts, back to the distinction that my Lord Justice Singh was drawing yesterday. My submission is that Lord Reed cannot be taken to have gone anywhere near that far in abortion services. And what Lord Reed was truly focusing on in abortion services were those challenges, centrally focusing on in abortion services, were those challenges where the challenge is by nature a challenge to a rule or a policy, rule including legislation. And he was drawing a pretty clear distinction between those cases, and it's a distinction which is very clear in his mind, at least, from past case law, because it's essentially the distinction he drew in cases like Christian Institute.
But that wasn't Belmarsh, and that wasn't Elon Kane, and that wasn't all the
Elon
cases he mentioned.
Elon Kane, I respectfully submit, Elan Kane was a case. Doesn't matter. Elan Kane was a case. Elan Kane was a case in which effectively what was being challenged was the rule that non-binary people could not have an X on the passport. And Belmarsh was in effect a challenge to the content of the subordinate legislation which gave effect to the policy in relation to the prison with three walls and the British versus
and primary legislation
and primary legislation
of incompatibility.
Exactly.
But the really difficult case for you may be Bank Mellet itself, because that's a review at appellate level, including at the level of the Supreme Court, of the facts of an individual case.
My lord, I can see the argument for that, but again, bear in mind, look at, let's have the paragraphs open, 2015.
Which case are we?
Sorry, we're in abortion services, so it's tab 44. Just before you get there, bear in mind the issue that is being considered here. The issue is whether or not the statement of principle by Lord Hamlin and Lord Stevens in Ziegler at paragraph 28 was correct. And that was simply about whether proportionality is, in essence, a purely fact-specific inquiry.
In the context.
That's the context. And it's
in the context of Ziegler.
In the context of Ziegler. But also bear in mind that abortion services, there was no first instance judgment. This was a reference from Northern Ireland. So they're addressing the issue they identify in paragraph 28 and say, well, there's the statement in Ziegler. Can that be taken as a general principle? And everything else that follows is addressing that issue. But come to the paragraphs that follow, 29, the view is mistaken. In the first place, the questions of proportionality, particularly when they concern the compatibility of a rule or policy with convention rights, are often decided as a matter of general principle rather than on evaluation of the circumstances of the individual case. And then cites a series of cases which were concerned with that. AI was immigration rules, I think Nicklinson was assisted dying, and SC was the two-child rule, as we discussed yesterday. In all of them, there was a challenge to the legislation or to a rule or to a policy. And they also demonstrate, see paragraph 30, the related point that it isn't just an exercise in fact-finding, it's an exercise of evaluation and so on. So all fine and dandy so far. 31 then is the reference to Bank Mellat. But you'll see that 31 is really about, that's reflected in the approach adopted by this court to appeals on questions of proportionality, cases such as those cited in the previous two paragraphs, all of which were about rules or policies or legislation.
But he says the same is true of other appeals concerned with rules or policies in which the facts of the individual...
Yes, but look how careful that language is. The same is true of other appeals concerned with rules or policies in which the facts were of greater significance.
But I mean, this case surely is concerned with the rule or policy in which the facts...
It isn't in relation to proportionality. It's about the fact-sensitive analysis and evaluation of proportionality in these individual cases.
But I mean, the actual proportionality test involves evaluating the policy against the individual circumstances.
It always will do in every single proportionality case.
Yeah.
Not necessarily. If you have, say, an extradition case, on one side of the balance will be the impact of a decision to extradite on the individual and his family. And on the other side, there won't be a policy. There will just be, if you like, the public interest in extradition of an offender.
Well, my lord, yes, of course, but in the vast majority then of cases to do with proportionality, what you're not doing, and there's a clear distinction between these two things, what you're not doing is to challenge a rule or legislation or the policy as itself disproportionate. There are those cases, lots of them are listed. And my submission is that all that can be taken from that final sentence of paragraph 31 and the analysis of, or the reference to Bank Mellat, Elan Kane is much easier. I agree that Bank Mellat is more difficult, but all that can be taken from that is that you're closer to that area. It is not saying that whenever you deal with the question of proportionality, the appellate court is in effect required to conduct its own analysis of proportionality, its own evaluation of the circumstances, rather than looking for whether or not the first instance judge was wrong. Now, of course I accept that it's not entirely clear precisely where the line is drawn, but if Lord Reed's conclusion was that in all cases of proportionality, the role of the appellate court was in effect a primary decision-making role as compared to the first instance court, then that could easily have been said.
Well,
that is not
except
what he said.
except this, he if quite clearly sidelines the extent to which one should be taking Lord Hamblin and Lord Stephen's judgment in Ziegler, and gives the impression that he, without expressly saying so, that he veers towards Lord Sale's version of events in Ziegler at paragraphs 129 to 135 or whatever it is. Now, I know Lord Sales went a bit further than probably one could properly say Lord Reed has gone here, but by marginalising Lord Hamblin and Lord Stephens, he surely is saying that is to be confined to that kind of case and that all other cases are in the same category.
Well, I'm not sure I would accept that breadth of proposition. He certainly does acknowledge that there are certain types of judicial review appeal in which proportionality is an issue, in which the court should adopt a more interventionist approach. A question that we are debating is what type of case? Is it the type of case where you just say...
I will let you finish, and I completely get that point you're making. What do we do? But interventionist, I think, is a rather charged word. What Lord Sales was saying is that you have a duty under the Section 6 of the Human Rights Act, and the courts are charged with responsibility for making sure that that duty is performed.
Yeah.
Now, that's not interventionist. It's only if the decision has fallen foul of those standards that you would intervene and you would, along the way, pay the margin of appreciation appropriate to government and the margin of appreciation appropriate to the court below.
My Lord, yes, I'm just not sure that helps you answer the question. The question really is, are you obliged as an appellate court to retake that decision as if you were the first instance judge, as long as it only as proportionality is raised?
But if there's been a permission to appeal on the ground that there's a reasonable grounds for supposing the balance was wrong, why not?
Well, that premise is effectively my submission, which is that you apply the wrong test, and you apply the wrong test at the stage of permission, you apply the wrong test at the hearing. That's my submission in a case in which you are not dealing with a challenge to a rule, a policy or legislation, which may raise much broader and more difficult questions. But in cases where you're simply doing proportionality with all the elements of evaluation and all the fact-finding, if it is the position that you simply retake it as if you were the first instance judge, then that does drive a coach and horses through things. And the question is, are you obliged to do that? I fully accept that Lord Sales focused on Section 6 of the HRA, but so did the Supreme Court in B, and they were undoubtedly right to say that the ECHR does not require an appeal at all, let
Yeah,
alone...
but they were looking at Section 6 for a different reason from Lord Sales.
Well, they were looking at Section 6 to see what the duty was on the appellate court, and whether or not the appellate court needed to do more than apply the traditional wrong approach in order to satisfy Section 6. That would have to be derived from a convention obligation which doesn't exist.
Maybe it comes down to what the traditional wrong approach is.
Well, maybe it does, and that's why there's some reference by Lord Reid to what wrong means, and it may be a flexible concept.
Yes.
I totally understand that.
You invite us, do you, Sir James, to apply the wrong, in quotation marks, approach as set out in Re B. Now, would you accept this? And I genuinely want your assistance on this. In Ziegler, in the divisional court, we said we're applying Re B. Wrong. And we were told by the majority of the Supreme Court that that was wrong. That we should have applied, because it was an appeal by way of case stated, we should have applied Edwards and Bairstow.
Yes.
Now, whether or not that was right in that context, in the present context, have I understood your submission correctly, that you submit that the correct approach this court should apply is the conventional one in Re B?
Yes. To apply the test of wrong.
Would you go on to accept, therefore, that is not confined to an Edwards and Bairstow question? For example, has the court below reached a conclusion which was not reasonably open to?
Yes, I would.
You accept that?
I would. That wrong is broader than Edwards and Bairstow. Yes, I do.
Yeah, so wrong isn't...
That was the distinction.
Wrong isn't simply we substitute our own assessment,
No.
but it's not as strictly confined as Edwards and Bairstow.
Exactly so. And then you get into questions of degree, potentially, if you're approaching it through that door, and you say, well, wrong is a flexible concept, and one can see the principled argument. I'll come back to it with just a shorthand, entirely recognising the point that the Master of the Rolls put to me about intervention as being a loaded term, but one can see a greater case in principle for intervention, or greater intervention by the appellate courts, including the Supreme Court, in circumstances where what is being challenged is either law, rule or policy, or something which is proportionality on the particular facts, but the logic will almost inevitably create the same effect. And if one was addressing it as a point of principle, what should you do in this case, given that there is, at the very least, potential for debate, to put it at its politest, about what those paragraphs in abortion services mean or imply, about where that line should be drawn and how the appellate court should go about approaching it. Can I just pull them together as the approach in principle in 4 short points? One, the point I've already made, the starting point is a line of relatively clear authority about the correct approach, including B, and there is no ECHR requirement, and therefore no HRA requirement, that the appellate court departs from wrong. That's undoubtedly the position. That's 3 points. Secondly, and these are broader points of principle, there is, I respectfully submit, there may already be, and maybe not much one can do about it, but there would be real and serious risks of complication the more complicated the appellate court's process has to be. It's one thing to divide along relatively broad case type lines. In other words, are you dealing with a rule or a policy or legislation, as compared to a case in which you're applying proportionality on the facts of individual cases. It's quite another to start trying to chop it finer than that, so you're, as it were, relying on fact versus evaluation or something of that kind. That was why I took you back to paragraph 41, the citation from Lord Hoffman in Paglowski. Biogen. Yeah. And I respectfully submit you can't escape from that difficulty by simply saying, well, this is a JR. All human rights cases effectively come through the JR route, or most of them do.
Well, actually, extradition, immigration, appeals, you often have live evidence in those tribunals. We mustn't lose sight of that.
You do, and it becomes a very complicated thing if you chop it too fine. So complication, it might be thought, if one was arguing it as a point of pure principle, it is a factor that the court would be entitled to take into account. But perhaps as significantly as the third point, which applies particularly perhaps at this level, which is that there are serious issues with serious implications if you go as far as, in effect, to say that whenever proportionality is an issue, or even whenever proportionality is an issue and the underlying basic primary facts, whatever that may mean, are not in dispute, however you put that, there are serious implications with all of that. Is it, if it's all JRs involving proportionality, or all cases involving proportionality, then that covers a very broad range of cases, because all qualified rights, or many qualified rights cases, will involve that. Proportionality is built into subpara 2 of all the qualified rights. It raises broader questions. Does that logic, or would that logic extend beyond the qualified rights and proportionality there into absolute rights? Query, query, Article 3, Article 2, the implied rights into those, which sometimes admit of something like the equivalence of a proportionality test. Have you undertaken reasonable investigations into a death, that sort of thing? Does it apply to those, this logic? And if not, why not? It might be thought to be perverse that the appellate court would take a greater and more intrusive reviewing role in circumstances where it's dealing with qualified rights but not absolute. Do you get a de novo hearing in all of those? In all of those cases, or even just in all the proportionality cases, a significant run of them, is that something which is appropriate and efficient for the appellate court to do? How do you determine permission? Reasonable prospects of success, what do you have to demonstrate if the appellate court is really there to just second guess? And maybe one can feather that by saying, well, you've got to look to see whether something might have gone wrong, or we might disagree.
Well, this comes down to what wrong means.
What?
Wrong means.
It does, to some extent. At least wrong gives you a flavour of looking for error. Whereas if you
There are two sorts of wrong, as I tried to say earlier. One sort of wrong is legal wrong. The judge misdirected themselves.
That's fine.
That's fine.
Yeah.
And we all understand.
Yes, yes.
The other sort of wrong is this doesn't smell right. The decision doesn't smell right. Looking at it as an appellate judge, I think the process that was gone through went wrong somewhere, right? Because for permission, you don't have benefit of legal argument. You don't have the benefit of oral argument. You don't have the benefit of going into it as deeply as you do orally. So it is quite possible to say there are reasonable grounds for thinking the judge was wrong in his evaluative exercise. What's wrong with that?
Nothing's wrong with that. That's my submission. That's the correct approach. That's the approach that's applied now. Right. My difficulty, I may respectfully say so, is if you broaden it out so that this court becomes in effect a de novo consideration of proportionality.
But I don't think Lord Reed is going that far, is he?
Well, it's a little unclear how far he's going beyond those cases which involve rules and policies or something
and I think
like
maybe we do need to look at it even more closely than we already have. But I read him as saying that what you do, that you can't just say that the court has no function in the proportionality exercise when it comes to appeal.
Yeah.
In other words, that the court must pay deference to the previous evaluation if there is no legal direction that is wrong.
Yeah.
And I don't think he goes any further than that. That doesn't mean that everybody will get permission to appeal, because when we do permissions to appeal, we just frequently, I mean, as in this case where Lord Justice Lewis said...
You have to do a sniff and touch or compelling circumstances.
Lord Justice Lewis said, I'm not giving permission on the ground I think there's reasonable grounds of success. I just think this is a really important case.
Quite. But the next case that comes along, when all the principles have marvellously been established, because it's not the first Russian sanctions case to hit the courts, as it were, you'll be confronted with someone on permission to appeal saying, well, if the position truly is that in proportionality cases where you're simply applying the proportionality test to the facts of an individual case, your role as appellate court is in effect to remake that decision for yourself, then that is, at least has very serious potential to impact not merely on the way you do it at the substantive hearing, but at the permission stage.
The problem is, and we've probably debated it around the houses, but the problem is if the judge on permission or this court thinks the evaluative exercise was wrong or potentially wrong, surely it does have a duty to put that right.
Yes, it does. But that's the test it has to apply. The test it is applying is wrong. It isn't the test that says you do it yourself. I mean, you remember Anyway, exactly. So you've got to look for some error or something that's gone wrong. I mean, there may be questions of degree, because you may so savagely disagree with the evaluation that it fits within that category. We all accept that these are amorphous concepts, but the real dilemma is, are you doing the thing again effectively as if you were a first instance court? And that's what I'm railing against, no more than that. The moment you introduce the adjective, then I'm content, as it were.
I don't think Lord Reed says that.
No, well, I respectfully agree.
Well, can I just ask you whether you do you have any submission to make to us about what Lord Reed says at page 2016 at letters B to C, where he expressly explains re B? Is there any difficulty in us simply applying that passage on your submission?
My Lord, the difficulty that I'm not sure I don't necessarily have a difficulty with his explanation that re B doesn't touch the proposition of principle that he was addressing. My concern would be if you take his analysis of re B so that it in effect became a general proposition the other way. You see what I mean by that? In other words, it doesn't...
What I'm really interested in is that he seems to be analysing re B against letter B to C in precisely the way I thought that you were submitting. It should be understood that where you have a one-off decision affecting only persons involved in the proceedings, that and particularly where the evidence was particularly well placed to take it, the approach by the appellate court is it should intervene if the lower court's assessment of proportionality was wrong.
My Lord, I do accept that.
That approach is capable of being applied flexibly.
Yep.
since the test or standard, it can be adapted to the context, as Lady Arden noted in Ziegler, and Lord Sales emphasised in his judgment.
Yes.
So as my Lord was, I think, putting to you a few moments ago, the sense one gets from Lord Reed's judgment here is that one should not follow the approach of Lord Hamblin and Lord Stevens in Ziegler, that although he may not endorse every word of Lord Sales's judgment, certainly the flavour of that judgment is more in the right area. Is that right? And this is giving us guidance, I think, on precisely our kind of case, where there's not a challenge to a rule or a policy,
Yes.
but it's a challenge to a one-off decision on its facts, and it's certainly not saying that we are confined to asking, for example, whether the judge below erred in law or reached a conclusion.
Not Edwards and Bairstow.
Exactly.
Yeah.
So I think it's somewhere in between. I think you say it's somewhere in between those two poles on a spectrum.
Yes.
Between total substitution of our own assessment
Yeah.
for proportionality as opposed to Edwards and Bairstow, and where it is exactly, he says it can be applied flexibly.
My Lord, yes, I agree with all of that.
All right.
The only concern about 33 is if you read 33 as being, well, because of these distinguishing features of re, B and R, you effectively go the other way.
Oh, I see.
And it may be that that is how some people are reading them, so that you say, well, what he's actually doing is in effect to confine B to the dustbin, other than in pure care proceeding cases. And my respectful submission is that would be wrong. My distinction is between rule, policy, or cases involving facts which are pretty close to that.
That I do understand, but can I just ask you one final question,
Yes.
please, on paragraph 33, that when Lord Reed addresses the decision in R
Yeah.
as distinct from B, would you accept that he does appear to be saying that it would be a mistake to attach undue significance to his statement, that in the context of a particular case you have to look for some, I don't know what he's saying.
You have to look for some other features, see
Yes.
paragraphs 29 to 31,
Exactly.
and the question that begs is, what are those other features? And my submission is that those other features are effectively rule or policy. So you need to be a bit cautious with taking Lord Carnworth as too broad and covering rule or policy cases. Does that make sense?
Yes, it does, thank you.
I mean, you would accept that this case is in between. If you took 3B at the one end of the spectrum, which is a factual analysis, and you take the challenge in abortion services, which is a legal challenge, this case is in between because there is factual material, but as we rehearsed a moment ago, the guts of the proportionality balance is between the importance of the rule, the policy decision the government has taken in enacting the sanctions regulations, and the factual effect on the person concerned.
My Lord, it certainly has those features. What I would urge caution on is that those features place it in the intermediate category, because invariably when you're doing a proportionality analysis, there is likely to be a legislative regime which opens up particular individual decisions to be made on proportionality grounds. They will always be pursuing a particular objective. You will always have the features of a bit of fact and a bit of evaluation, with all the difficulties of disentangling those two. And the moment you start going too far down that road, it does become complicated, it does become problematic. My ultimate submission is to agree with the way in which my Lord Justice Singh was putting the point to me, but to add the note of caution, which is that if you are going to do something as radical as to say effectively all JRs, or all JRs that involve a bit of proportionality and therefore a bit of evaluation, where most of the facts might be, the primary facts might be relatively clearly established without cross-examination. If you're going to go that far, that's a long, long way, and that is something which should not be done at this level. If the Supreme Court want to go there, well, they can tell us where the dividing line truly lies and we can have the argument of principle. But at this level, I respectfully submit, there is merit in adopting a relatively cautious approach to precisely how far these paragraphs actually go. And that's why I say that read in that sense and in that light, the correct distinction for you to apply is to say, of course, he's clearly acknowledging that when you're dealing with a rule or policy or something very like it, that's one approach, because you're effectively challenging the legislation or the policy or the rule. It's quite another thing if you are saying that proportionality as applied to individual cases, recognising, of course, fact, evaluation, all the other things that go into proportionality are in there, quite another thing to say that those cases require you to adopt a more interventionist approach beyond.
Some would say we're bound by Lord Reed said.
You are, as long as you can discern the meaning of Lord Reed, and that's what we're debating. I'm not disputing the proposition that you're bound by the Supreme Court. There is often a
But
question.
when you say we must be cautious and not go too far,
You better be a bit cautious if what
how-
you're doing is reading the bones that have been thrown.
Yeah. Okay. Lovely.
My lord, we've probably taken up enough time.
It's a
on that.
fascinating,
It is interesting.
fascinating point.
It is, and difficult.
And difficult.
Those are my submissions.
What we're here for. It's what we're here for, to
That's what
decide
we're here
difficult
for.
points.
Yes, my lord, of course. I'm sorry if I've taken rather longer and made it laborious and more complicated for you, but I hope the submission is clear at least. And you'll appreciate that our position, which is why the skeleton argument says entitled/right, is it doesn't terribly matter how interventionist you are on the facts of the individual cases. Can I turn to respect, margin, and all of that? We submit, as you know, and as both judges found below, that there is very considerable margin to be accorded to the judgments of the government in an area such as this. That is essentially and principally because the regulations and their application in individual cases sit in the context of and require judgments about foreign policy, foreign relations, how foreign states and other individuals are going to react, predictive assessments, and all of those things that traditionally underpin a broad margin. Reg 6 in particular, and all the rational connection test in particular, requires judgments of precisely that kind. And the reason why respect is accorded in relation to those sorts of judgments is both because the executive has particular institutional competence, as it's put, or expertise, and because it has the constitutional responsibility for making these sorts of decisions, which are, after all, designed to try and influence and achieve the desisting of the Russian aggression and worse in Ukraine. And the identification of foreign policy levers by which to influence that behaviour is a matter on which the Secretary of State has particular expertise, including, if one wants simply an example, in the detailed understanding of how, in Russia, the systems of patronage actually work, and therefore in making judgments both on that basis and on broader bases as to what things are likely to contribute to the achievement of that overall objection. And there is, particularly in Mr. Abramovich's SDF core bundle, tab 17, page 219, quite a detailed section on patronage, which is of some interest in the present context. And that respect is, of course, accorded, and this will be very, very familiar to the members of the court, but it's accorded under our domestic system. We call it margin for shorthand. There is, of course, a distinction between the respect that the ECHR, the European Court, affords to domestic judgments, but in our constitutional arrangements, precisely the same approach is applied, but is applied on the basis of our constitutional arrangements. See Lord Hoffman in Raymond and all the cases that follow that. So far as the authorities are concerned, can I just pick up a couple of them that have been alighted on by my learned friends? The Belmarsh case, first of all, if you would, tab 15, page 640. And you will need, certainly Lord Justice Singh will need no reminding of the very particular and very fraught context of the Belmarsh decision. It involved, as all of the judges relied upon in their proportionality analysis, a detention, so a deprivation of liberty. See, for example, Lord Nichols at paragraph 81, thoroughly emphasising, unsurprisingly, that feature. It also involved established discrimination. And just to put that into the facts, again, as my Lord Justice Singh will recall, because there was, as it were, a penny-dropping moment, as I recall, before SIAC, in which my Lord was making some submissions, and the frisson went down the back. But the basic point was that from the key perspective of the objective, which was combating terrorism, the facts were essentially not in dispute. Precisely the same justification applied to the prevention of terrorism from British as from foreign. So where, by reference to the objective justification, I think was the rhetorical question, is the distinction between them? At which point there was what might be thought to be relative silence on the part of the government submissions. But that was the context in which the issues arose. And one needs, therefore, to be careful in understanding that context and those features, and also careful, I respectfully submit, in understanding the argument that, in particular, Lord Bingham was dealing with in some of the key passages to which reference was made. You will recall that the broader context of Belmarsh was, of course, a derogation. And what required to be demonstrated under Article 15 of the Convention was that the derogation there from the right to liberty was strictly required by the exigencies of the situation in the context of a public emergency. And the passage to which, on which reliance was placed in particular in Belmarsh at paragraph 42 on page 682 does need to be understood in the context of not merely the fact that you were dealing with, the court there was dealing with strict necessity in the context of a derogation, which one gets from 684 between A and B, that's pretty clear from there. But 42 itself was addressing a very particular argument. And the particular argument was that the courts made, I think by Lord Goldsmith, was that the courts had no business going anywhere near any of this. It was almost a non-justiciability argument that was being run, and that is being rejected. That's the limit of what is being considered in 42. You will see the way the argument is summarised by Lord Bingham at the letter E on page 682. The appellants are entitled to invite the courts to review on proportionality grounds the designation order and the compatibility. They're not effectively precluded by any doctrine of deference from scrutinising the issues raised. That was all he was addressing. Were the courts effectively shut out from that? Answer, perhaps unsurprisingly, no, for the reasons that he gave. But that's all that's being dealt with there. But the key point, perhaps for present purposes in relation to Belmarsh, is that it positively supports the clear line of authority that's been addressed in countless Supreme Court cases since, which is that in appropriate cases, proper respect is to be accorded to the judgments of the executive. In the particular context in which that arose, namely whether there was a public emergency threatening the life of the nation, which was described as a political judgment by Lord Bingham, he positively acknowledged that in that context and for that purpose, a particular respect was due. Indeed, that was, it might be thought, dispositive to his reasoning on that issue. See paragraph 29 on page 674. Which you've seen. And you'll see the citation of Raymond between F and G. So it's entirely clear that in a proper case, and for proper purposes, as it were, respect or margin is to be accorded And one sees that from the range of cases that you have before you, including first of all, Al-Rawi per Lord Justice Laws, which is about as frequently cited as Lord Hoffman in Raymond. We can probably take that, I think, from Lord Sumption's judgment in Carlisle, which is behind tab 28, and the relevant paragraph for present purposes is paragraph 33, page 1487. I'm going to this run of cases principally because they are cases that deal with the according of margin or respect when you're dealing with foreign relations judgments, which was paradigmatically what Lord Carlisle was about. It was how Iran was going to react if we were to let a particular individual come into the United Kingdom to address parliamentarians. And you'll see Lord Sumption on page 1487 citing, with the introduction that seemed to him to be much wisdom in the observations of Lord Justice Laws, by the letter E. Do you see that? And then he cites the very well-known paragraphs 147 and 148.
Yeah. I do see that, Sir James, but could it be said that there are dangers if one reads paragraph 148 at least on its own, because that comes, it might be said, perilously close to posing the test as being one of rationally considering?
Well, my lord, again, perhaps this whole area has been a bit bedeviled by the language. Once you have a broad margin, that effectively can be analysed as opening up a broader range of reasonable decisions for the decision maker. That's the consequence of affording margin, and that's why courts have often drifted into that language of range of reasonable responses, and range of reasonable responses, as you know, is often used to describe rationality. But that's why that drift occurs. There's nothing wrong in principle with referring to a range of reasonableness. Indeed, we'll come to it in a moment. But that is also, well, we'll come to it now, if you will. That is also what Lord Sumption does in the key paragraphs in Lord Carlisle. You've seen Al-Rawi, as cited by him. If you go in Lord Sumption's judgment back a bit to page 1480, you will see that at 19 and following, he makes points about margin, including in particular at paragraph 20, relying on Lord Reed in Bank Mellat. We've just cast an eye down para 20 and then para 21. So he starts with Bank Mellat, but particularly those bits of Bank Mellat that emphasise the appropriateness of according margin, paras 20 and 21. Then he conducts a detailed analysis, or a little bit of analysis on whether deference is the right phrase, and worries about its cringing abstention implications in paragraph 22 by the letter B. But more importantly, he then cites and relies upon the analysis of Lord Hoffman in Raymond on margin, and Lord Hoffman in Raymond referred both to national security and to foreign relations. And he's doing so, as I say, in the context of a question about pure predictive assessment of how Iran might react if particular things are done by the United Kingdom. So it's important that he relies upon and finds support in the analysis of Lord Hoffman in Raymond. That's of particular importance because we sent you two authorities. You have two authorities on your desk, one of which is Begum. I don't invite you to pick it up now because we're still in Carlisle, but Begum is very well known in the Supreme Court. We've given you Mr. Justice Johnson, which was a few weeks ago on sanctions, which I'll come back to again on Russian sanctions. But we've given you Begum because, likewise, Lord Reed's analysis in
I
Begum.
haven't got Begum, actually.
Have you got Begum?
I haven't got Begum. I mean, I know the case, but I'm not sure I've got a copy of it here.
Does my Lord Justice Singh and my Lord?
I've got it.
I have it.
Do you have Mr. Justice Johnson?
I do.
Thank you. Your word.
Thank you.
I'll come to it in due course if I may, but you'll recall that Lord Reed centrally based his analysis in Begum about margin on Lord Hoffman in Raymond, and indeed Lord Carlisle. Lord Sumption is doing exactly the same thing. So those are the first key paragraphs, and then 32 and 34 are the key paragraphs, as we all agree,
So 32 and 34 back in.
back in Lord Carlisle.
Yes.
Can I tell you, Sir James, what I think I derive from paragraph 34 and just invite you to read? Because one is trying to find principles here.
Yeah.
The first point is that the court is the ultimate arbiter
Yeah.
of the appropriate balance between two incommensurate values. That's against letter G. The second is that the context affects how much. Sorry, the second point is at letter H and letter A on the next page. The court is entitled to attach special weight to the judgments and assessments of a primary decision maker with special institutional competence. And the third that I derive from this paragraph is that how much weight should be given depends on the context. See letters D to E on the previous page. It will depend on the significance of the right, the degree to which it is interfered with, and the range of factors capable of justifying that interference, which may vary from none at all, Article 3, to very wide-ranging considerations indeed.
Yeah.
But the legal principle is clear enough. The court must assess the adequacy of the factual basis claimed. Is it sufficiently robust, having regard to the interference with convention rights, which is involved? I mean, is anything that I'm putting to you controversial?
No,
I think.
it isn't. It isn't. The only thing we would invite you to double sideline as well in relation to at least one of those points. I think the point that drifted between pages 488 and 489 are the lines that precede that, but 2 lines below G. But the court is not usually concerned with remaking the decision maker's assessment of the evidence assessment reasonably open to her on matters of judgment. So that's where you get this drift, as it were. So in other words, there shouldn't be a red light just because you see the word reasonableness. And my respectful submission is that that's entirely right in principle. Margin is effectively doing that. It's broadening the range of reasonable decisions that are open. None of that touches the point, but of course the primary decision maker here is ultimately the court because it's proportionality. It's about how the court goes about addressing those questions where issues of judgment, to which respect is due, are in play. But my lord, no. The only other point perhaps to bear in mind in relation to this, and I'll come back to whether there was error committed by Mr. Justice Garnham, as my learned friend suggests, but you will bear in mind that the 2 key paragraphs from the authorities that he cited essentially distilled into 32, or a bit of 32, and most of 34, if not all of 34, from Carlisle. Those were the passages that Mr. Justice Garnham cited and relied upon in directing himself as to the law. And ultimately, my learned friend Lord Anderson, entirely unsurprisingly, said, well, I can't do better, in answer to my Lord Master of the Rolls question, how do we go about doing this, than 34 of Carlisle. But 34 of Carlisle was obviously the same thought had occurred to the judge, because at paragraph 88, that's the paragraph he cites. So that is Carlisle, and as I say, Carlisle is as it were, smack on point, because it's foreign relations and foreign judgment about how foreign states will react and what will happen if individuals are afforded things, and its predictive assessments and all of the other things. So just to show you briefly Begum very well known, and in relation to Begum, you will see, if you go to paragraph 51 of Begum, page 790 in the law report, you will see the intensive citation from Raymond, though very much echoing Lord Sumption's analysis in Carlisle. 51 is the reference to Raymond, which is then analysed. See in particular on that analysis, the analysis of Lord Hoffman's speech at paragraph 55. And you'll see the distinction which is being drawn, although it correctly said section 4, which was the full-blown appeal, as it were, it gave it full jurisdiction to decide questions of fact and law. It did not make sufficient allowance for certain inherent limitations, first in the powers of the judicial branch of government, and secondly, within the judicial function in the appellate process. The limitations, picking it up at 56, you'll see on judicial power arose from the separation of powers. And you'll see the various different justifications for that position, then analysed in the subsequent paragraphs, including at paragraph 60, where you'll see it places reliance on Lord Hoffman's explanation that there is a need, as Lord Hoffman put it, in matters of judgment, and now in paragraph 60, in matters of judgment and evaluation of evidence to show proper deference to the primary decision maker. And then he explains why that is. It involves an evaluation of risks, paragraph 61, on which there's lots of institutional expertise, 62, democratic accountability, references in the tail end of 62 to Belmarsh, and also to Lord Carlisle. And so they conclude broad margin there. In relation to national security, of course, it's different. They were considering the scope of the appellate function in that case and how broad it was. And even though it was an appeal on fact and law, nevertheless, it was a concomitant of the judicial function to accord those respects, even within that breadth of jurisdiction. And of course, it's about national security. But as we know, Lord Hoffman in Raymond applied the same reasoning essentially to foreign relations, and you have direct authority on that in relation to foreign relations in Lord Carlisle. None of that, we respectfully submit, is dissonant in any way with Bank Mellat. Bank Mellat is at tab 27. If you could go there, 1339 it starts. Bank Mellat does not involve, or put it the other way around, Lord Carlisle does not involve some form of Damascene conversion by Lord Sumption to the view that margin is appropriate. You get the same thought in Bank Mellat at paragraph 21 in his judgment in that case, page 1410. taken to this, but it's an important paragraph for establishing the principle. Large margin of judgment and so on. Preeminently a matter for the executive. Last 2 or 3 lines of paragraph 21. And then positively agreeing with Lord Reed and the approach in principle, even though they disagreed on the application of those principles to the facts. And the particular bit, which it might be thought paragraph 21 is agreeing with, is the passage that I invited the court to read when which my learned friend was kind enough to draw your attention to at my invitation when he was taking you to this case. If you go forward to paragraph 71 on page 1428, you will see the approach in principle that Lord Reed adopted and that Lord Sumption agreed with. We thought it was right that you should have, just because it's a case in the same territory, albeit of course first instance, Mr. Justice Johnson's decision in Phillips, which was the other handout. And he summarises the principled approach to be taken, in particular at paragraph 137. To some extent relying upon Mr. Justice Garnham and Shvidler, to some extent setting out a helpful summation of the relevant principles, which would appear were common ground in that case. If you look at 137, I don't invite you to read it all through now, it'll be pretty familiar stuff. Note in particular sub 10 on the issue I'm on now, and the way in which that should be approached, in which he adopts Mr. Justice Garnham, paras 91 and 92 at paragraph 138. And just for good measure and to stop me having to go back to it, in relation to rational connection, I would invite you just to sideline paras 149 to 151. This is the in aggregate point. Therefore, those are the authorities to which I invite the court's attention. Can I turn to the judgment of Mr. Justice Garnham? The relevant paragraphs are paragraphs 88 to 92 in the judgment of Mr. Justice Garnham, Corbandel and Shvidler, page 96, if you're doing it electronically. And I make the overarching submission that not merely did the judge cite what we all agree is the best guidance from the Supreme Court about how you go about doing this exercise, but he then faithfully applied it. He clearly recognises, as the rest of his judgment shows, that these are issues for the court to determine, but in making that determination, the court can and should accord respect on an issues basis, in effect. So it's a faithful application of paragraph 34 of Carlisle, which he cites. Lord Anderson is not saying, he made clear, that there was any error in the sense of the judge not appreciating that the decision was ultimately for him. He was also not saying, as he was assiduous to point out, that the judge was wrong to give weight to the primary decision maker, although it might be thought he came perilously close to making something like that submission by reference to a suggestion that it might only be appropriate to do so in relation to the first of the Bank Mellat limbs. In other words, what's the objective? That's plainly wrong, I respectfully submit, as Lord Carlisle, Power 34, makes entirely clear. The first criticism that is made by Lord Anderson of the judge's reasoning is that he fell into error because he did not recognise that close scrutiny was needed in the proportionality exercise and in making a judgment about the proportionality underlined of the decision. He says the close scrutiny exercise was applied too narrowly and not to the decision. Well, we respond to that by submitting that that's simply wrong on any fair reading of the judge's judgment. He applied Lord Carlisle paragraph 34. The first sentence of paragraph 91 of the judge's judgment is positively inconsistent with that suggestion. Whether Mr. Justice Garnham said, undoubtedly, this is a case where close scrutiny is necessary, quote, in order to adjudicate on a complaint that convention rights have been infringed, and it's a structured analysis articulated in Bank Mellat that must be applied. But he's also right, that Mr. Justice Garnham was plainly right to note that the court does not assume, as the courts have repeatedly stressed, the role of primary decision maker on issues that turn on the exercise of judgment or the determination of policy.
Is the next bit correct? I mean, you yourself submitted only a few minutes ago that the court is the primary decision maker, and Lord Sales says that in Ziegler. And
are you referring to the sentence, but the court does not assume the role of primary decision maker?
Limiting itself instead to ask whether the decision was one properly open to the executive.
Yes, but you can't miss out the middle bit of that sentence, my lord. The court does not assume the role of primary decision maker on issues that turn on the exercise of judgment or the determination of policy. That's what he's saying.
Yes, but
And
is
on
that
there-
right? Even on limb 1, is that correct?
Yeah, my lord, it is.
On limb 1, you say the court can only ask whether the decision was one properly open to the executive, whereas on limb 3, the test is different. Is that your submission?
No, my submission is that this is an issues-based judgment. Is the issue that you're considering one which is appropriate to accord respect on? That's the essence of all the reasoning from the Supreme Court that's gone before that I've taken you through.
Get that.
And if, therefore, there's a question of foreign judgment, foreign relations, or how a state will react, or how a predictive assessment in matters in that sphere, then that is a judgment on which respect should be accorded. And you do not step into the role of primary decision maker, as Lord Sumption made absolutely clear at the tail end of paragraph 34, which the judge cites.
Is there an unhappiness of language here in the third line where he says limiting itself instead to asking whether the decision was one properly open to the executive? Could that have been better phrased as being, I'm taking the decision myself, but I will accord weight to the views of the executive?
My lady, it could have been placed in that way, but that is...
And we may be dancing on a pinhead, but I'm just trying to get straight.
that is the approach that was taken. What he did was to say, I need to look at the issue. Is it an issue on which margin or respect is to be accorded? If it is, the effect of according margin is to expand the range of reasonable responses open to the government. And so it isn't just a question of the court saying, well, I would have reached a different foreign policy judgment. So it is to some extent a shorthand, but it isn't a shorthand that causes any difficulty in principle. And indeed, the concept of reasonableness is referred to regularly when they're treating margin in the Supreme Court, as indeed is evident from paragraph 34 of Lord Sumption in Carlisle.
Well, I mean, it does look, doesn't it, as if it's a confusion with the judicial review test.
My Lord, I respectfully submit it plainly is not that. He's not confusing it with a judicial review test. He's entirely clear that these judgments are ultimately judgments for the court, but the question is, how does the court go about doing that? And the answer to that is, in certain instances and in relation to certain issues, it does that by according marginal respect. And what that does, in principle, is to open up a question as to whether or not those were reasonably open. Those were within the range of reasonable decisions for the decision.
Well, your point, I suppose, is that he cites the law correctly, and if he then describes it infelicitously, we shouldn't regard that too harshly.
My Lord, that would be an alternative submission. My submission is that he hasn't even described it infelicitously.
Okay.
You need to read the judgment as a whole, and that paragraph as a whole, and as you will appreciate, the sentence that follows the one you're focusing on then goes on to make it absolutely clear that what is being done is to recognise the constitutional competence of the Secretary of State and his officials on matters of foreign affairs, attaching particular weight to the judgments of a primary decision maker with special institutional competence, who's considered all the relevant material. That's what he's doing. But the consequence in principle is to broaden the range of reasonable responses. So the court doesn't just say, I disagree, I would have reached a different decision on that foreign relations judgment.
Can I ask you about a submission which is attributed to you? And please, if this is taking things out of turn, please do defer this. But at paragraph 135, on page 104, in the second half of that, I think this is recording a submission. And it ends with the question or the proposition that the Secretary of State was entitled to conclude that the claimant's designation was proportionate. Now that, could it be said that that is redolent of the pre-Human Rights Act test? In other words, what we used to ask under Bryn.
Well, my Lord, if the error is mine, the error is mine. But we've been, as it were, collapsing the concepts, potentially. But there isn't an error of principle here, because even in relation to fair balance, that question of fair balance must throw in all those matters on which respect is to be accorded and margin is to be accorded.
Again, I understand that, Sir James. And on less intrusive measures, and again, please don't take this out of turn if it's wrong to do so, but on the same page at paragraph 131, and this is not recording a submission, this is the judge's own reasoning. He says, all that can be, is not one on which the court can second guess the Foreign Office. All that can properly be said is that the government's analysis is not self-evidently irrational or outside the range of reasonable response.
Yeah.
Right, now, again, maybe it's a question of wording, but words...
I suspect it is a question of wording. Of course he refers to irrationality there,
yes,
and gets away from that, but or outside the range of reasonable responses. It's in essence this idea that when you're applying margin, you then have to ask, in essence, what's the effect of doing that? And the effect of doing that, as we know from all those Supreme Court authorities, is that the court doesn't just do the judgment for itself. The whole idea of according respect or margin is not to step into the shoes of the primary decision maker, and what that means is you ask that reasonableness question. That's why both in relation to intrusive measures, I think it's paragraph 75 of Lord Reid in Bank Mellat, and Lord Carlisle, Lord Sumption, they both refer to and themselves drift into that language of reasonableness when they're explaining what the concept means. So unless it's, as it were, clear that what the judge is doing is to conclude, we had a much starker example, as you'll recall, or some of you may recall, in the Rwanda case, where the judgment below really was difficult and redolent with some of those issues, as the Supreme Court found in the AAA case. But there's no doubt here what was going on. No one was suggesting at any stage that this was anything other than a question of proportionality, which was for the court to determine. No submission to the contrary was made.
is it not a problem? I mean, I'm hugely sympathetic with judges of first instance who are faced with this raft of Supreme Court and Court of Appeal authority, which doesn't always sit easily end to end. But having said that, it is a problem when a judgment in an important area like this, as you say, drifts into the language of reasonableness without making it clear what actually is being done. Because the reader of the judgment, and in this case that is Mr. Shvidler, is surely entitled to know that the correct legal test has been applied throughout the judgment, and not to fear, in reading this paragraph, that the judge has actually just confined himself to asking whether the government's analysis was either self-evidently irrational or outside the range of reasonable responses.
Well, my lord, of course there is that danger, but my respectful submission is that reasonableness, at least, is not problematic in any shape or form. Just go back to paragraph 34 of...
Well, I mean, I think you, without... I mean, okay, by all means we will, but my question is, if what the judge was doing is asking himself whether the government's analysis was not self-evidently irrational or outside the range of reasonable responses, that's not the right thing to be doing.
Outside the range of reasonable responses is the right thing to be doing.
But the first one is not.
Well, the first one is a summary, in effect, of the other one. He's not saying I'm applying...
You wanted to go back to 35?
34.
34.
Go back to paragraph 89 of the judgment. Halfway through, two-thirds of the way down that, but the court is not usually concerned with remaking the decision-maker's assessment of the evidence if it was an assessment reasonably open to her. Could it be said, well, Lord Sumption's using that phraseology, and the same thing you see in Lord Reed in Bank Mellat. It's just a reflection of what the margin does. So the critical thing is, does the court recognise that this is a decision for it to take? It's got to make its own judgment, and that is entirely clear. It's entirely clear that that is what the judge is doing. In all of the analysis that follows. He's testing the evidence, testing the judgments that are made, but he's properly applying.
I mean, what I get that submission.
Assessment
yes.
reasonably open. But we're on the language.
Well, we are. And I get the submission that if you say, well, this was an assessment that was reasonably open to the decision maker, what you're actually saying is applying an appropriate level of deference to what the decision maker knew. I would not say that decision was wrong. It might not be a decision I would have made myself had I been the original decision maker, I prefer, rather than primary. But it is unhelpful for the reader for those two concepts to be elided. And what I'm concerned about in this case is that whatever we decide, we provide a certain degree of clarity for first instance judges. And the problem is that this judgment, to me, when you finish reading it, you're not quite clear what the judge was doing at the various stages. Now, do you disagree with that, but say, well, I mean, because it's always open to you to say, well, whatever he did, he made the right decision. Obviously, you might say. And we will have to consider that, even if we decide he got it wrong.
Well, my lord, if necessary, I say that, but I make the primary submission that he didn't go wrong.
Yeah. Okay.
And that the consequence and effect of margin is to open up a range of reasonable decisions for the primary decision maker. That's the proper approach for the court.
You would applaud the idea of clarity, would you?
I support the idea of clarity, and I would certainly also support potentially the suggestion from the court that however much it may be an elision or a description, alternative description of within the range of reasonable responses, which is often traditionally the description of substantive irrationality, it might not be terribly helpful to use the concept of irrationality, but I would not accept that referring to when in territory where a broad margin is to be accorded, referring to the range of reasonable responses is an error at all.
You see, the problem for a simple private lawyer is the propensity of administrative lawyers to mix up in a huge melting pot the words proportionality, rationality, illegality, and reasonableness.
Well, my lord, it's perhaps unsurprising that they do a bit of that because everyone accepts
because
that...
the courts do.
Well, courts do, but also everyone accepts that proportionality, whilst of course engaging a primary decision-making function in the court, as it were, nevertheless it is entirely clear that you apply margin to various types of issues, and when you apply margin to various types of issues, it as I say, it opens up that range of reasonable responses, as Lord Sumption points out.
But we need to have clarity of terminology in order that these confusions don't occur, because if you take the primary decision maker point, that term is just confusing, because primary decision maker is different from original decision maker, and primary decision maker in the courts is different from primary decision maker in government. So we do need to be clear what we're talking about.
Well, that was part of the reason potentially for referring you to Mr. Justice Johnson, para 137. Mr. Justice Johnson, para 137, makes it absolutely expressly clear. The judge here may have felt he didn't need to, because no one was suggesting these weren't ultimately decisions for him. But he makes it absolutely clear that the court must decide for itself whether the interference with the convention rights is justified, rather than it being for the court to review the defendant's decision that the interference is
There's no
justified.
appeal I know of from Mr. Justice Johnson.
There's no appeal, no. But my short submission is that if you wanted clarity, then you get that. But it wouldn't affect the substance of any of this, because when you get to margin, when you get to the issues, its range of reasonable responses is a reflection of what margin is actually doing. That's what Lord Sumption says. That's what Lord Reader said. And that's what the judge did, absent that one single reference, as it were, to irrationality, where he seems to be using that as, in effect, an alternative description of range of reasonable responses.
Thank you.
So we do not accept that an unduly deferential, which was the second criticism, an unduly deferential approach was applied by Mr. Justice Garnham, or that he erred in any shape or form in principle. What my learned friend does say is that there shouldn't be accorded any respect, at least in relation to limbs 2 and following, because this was the reasoning of officials, because the Secretary of State did not rely on any closed evidence, and because Mr. Reed's 8 rational connection points postdated the decision. Those are the 3 bases on which he attacks margin. And I respectfully submit in answer to that, as to the first one, which is that this was the reasoning of the officials, that makes no difference whatever. We've dealt with that in our Skeleton, paragraph 42. Respect is accorded because of institutional expertise, not personal expertise of the Secretary of State himself or herself. And Kaltona operates. There's no challenge to that. Indeed, the designation decision itself and the decision to maintain designation following the ministerial review was also made by FCDO officials under Kaltona. See Reed 1, paragraph 25. Secondly, the closed evidence point as a reason for saying no margin or reduced margin goes nowhere. You do not just get respect or margin if the material is closed. That's just a completely different point. I described it as a red herring yesterday. I may not be quite the right description, but you know what I mean. And the reason why it doesn't take the matter any further is because although, of course, national security, see Raymond, is one of those areas on which proper margin is accorded, the acknowledged bases for margin are self-evidently and on authority broader. That's why I took you to those cases that were specifically concerned with foreign relations, predictive judgments and all of that. And it's unsurprising that the bases are broader, because the principles underpinning for margin, again, as is very well known, and as has been repeatedly and squarely acknowledged in a series of judgments, including Carlisle by Lord Sumption, and indeed by Lord Reed in Begum, the principled underpinnings for margin are very well known, and they are institutional competence and democratic accountability. And that's why they don't just apply to national security or secret or sensitive information, they apply to foreign relations as well. If the point is put more broadly, so as to seek to require specific evidence, if that's the point that's being made, I submit that you don't need specific evidence. These are predictive and evaluative of behaviour of third-party individuals, including in particular of a foreign state and those who are running it, and of the effectiveness of foreign policy levers. That isn't something which either needs to be or perhaps is even capable of being subject to empirical proof or evidence. And indeed that is a point that is emphasised by Lord Sumption in Lord Carlisle at paragraph 32. And so much of that logic, much of the judgments that are made are matters of logic based on and evaluation and predictive assessment based on expertise, which is institutional. The fact that Reed and his 8 factors are, as it were, post-decision is neither here nor there, because we're all agreed that the correct approach applying misbehaving is the one correctly applied by the judge at paragraph 95. What matters is that the measure taken breaches the rights. Both parties put in large tracts of evidence that post-dated the decision and that were considered and responded to in Mr. Reed's evidence. And the judge considered all of that.
Isn't there some authority, I think including in misbehaving itself, that when it comes to weight, the weight to be given to the judgment of the executive, that at that stage of the analysis, it may be material that they didn't take it into account at the time of the decision.
It's possible that, but it slightly depends on what you're treating as being the decision. And here, of course, as we know, the decision-making process, at least, included the very voluminous representations that were made by Mr. Shvidler, so it's a principle that inures essentially for his benefit, and we'd expect those all to be taken into account and responded to, and they were. And that was the substance and the reason for the detail in Reed 1. And so my respectful position is that even if in certain circumstances it might do, one needs to be a little cautious, because it's a subject, I think, considered by the Supreme Court in SC, but I think in relation to legislative reasons and all of that. But not quite the point my Lord is on, but my respectful submission is that you don't need to grapple with that here, because everyone accepts that this was part of the decision-making, effectively. And all of these things were being done pursuant to Carl-Toner anyway. I wanted to pick up, if I may, as before coming directly to the Bank-Mellat criteria, and I'll have to whiz a bit, but I wanted to come to arbitrariness and discrimination, which was quite a feature of my learned friend's submissions. And the first point to make is that I do not, of course, dissent from the proposition that if the facts are clear and they create a situation in which the application of a measure to one group, perhaps one ought to add with a status, means that there is no logical reason for not applying it to another group, then that would sound indiscrimination and potentially also in rationality and proportionality. Again, one remembers the detail of Belmarsh, in which there was quite a focus. I think Lord Bingham referred to the authority, and it's Lord Hoffman, I think, in the Privy Council of Matadine and Pointu, axiom of rational behaviour, all of that. That's no difficulty with that proposition at all. That was the position in both Belmarsh and in Bank-Mellat. take Belmarsh as the example, the objective of the measure, as I indicated earlier, was to deal with the threat from terrorism. But that threat was posed equally, no distinction at all, by foreign people and British people. But the measure only applied to the former. So exactly the same justification for the measure necessarily applied to the comparator group. That was the vice, and that was the basis on which both discrimination was found, unjustified discrimination was found, and proportionality was undermined. But that simply doesn't work here. Here you've got an intensely fact-specific analysis with nuances about, for example, the prospects of influencing decision-makers in Russia. You haven't got identical facts between the two comparator groups, as it were, and then a logical sequence necessarily flowing from them by reference to the objective. And what my learned friend sought to do was to derive that comparative effect and to draw the analogy with Mellat and Belmarsh inappropriately, we submit, from the mere fact that the criteria for designation might be met in relation to different groups. But that's impossibly broad as an approach for obvious reasons, because all of us agree that they are indeed broad and that proportionality, brackets individual factual analysis, needs to be considered and was in fact considered. Look at the same point from a slightly different angle. It cannot be unjustifiably discriminatory or arbitrary not to apply a designation to anyone and everyone who meets those criteria. All of those who satisfy the conditions do not contribute to the objective to the same degree. We also note that the judge here found the discrimination argument to be hopeless, as it was an inference without foundation for very good reason, I respectfully submit. And he doesn't have permission to appeal that. So we're entirely unlike Belmarsh, where the discrimination was clear, and by reference to the objective, the logic was clear and damning. As I say, the premise for the discrimination argument was in any event hopeless. You're not required to designate. It wouldn't be discriminatory not to designate everyone who meets the criteria. You can make judgments about the likelihood, the degree of impact. You could also pick, I think was the example of mine, all the Master of the Rolls give. You could have a policy decision that says we can only cope with 100. There could be nothing objectionable about that in discrimination or arbitrariness terms. So I don't go through all of the submissions I made on discrimination below, because that isn't necessary. But I do respectfully submit that the attempt to suggest, by reference to the false analogy with either Mellat or Belmarsh, is fundamentally flawed for the reasons I've just given. Can I turn then to the Mellat criteria? And I start with the importance of the objectives of the designation. And the submission is the obvious one. Could not be more important as objectives given Russian aggression and conduct in Ukraine. Anything that contributes or is capable of contributing to altering that behaviour pursues a thoroughly important objective. The context surrounding the introduction of the Russian sanctions regime was explained in Read 1, paragraphs 6 to 22, and it's been added to and expanded over the years, no doubt in a parliamentary, as it were, attempt to seek to ensure that as many levers as can possibly be used are in fact used. The regulations were made for the purposes that were set out in sections 1, 2, C and D of SAMLA, which you've seen, and I don't go back to them, in the interest of international peace and security and the further foreign policy objectives. And Mr. Reid, in his first statement, picks those up and explains why those purposes are so important in the present context. See especially paragraph 13 of his first statement cited by the judge at paragraph 81 of the judgment. and the devastating effects of the Russian invasion are described in some detail. If you want more, in Read 1, paras 14 to 17. We also note that the judgment at paragraph 52 includes the relevant quotation from the section 2.4 report, which was laid before Parliament in April 2019 to explain why the Minister considered that the purposes of the 2019 regs fell within those SAMLA purposes. And as you've seen, the regulations themselves in Regulation 4 set out the purpose in terms. So the Russian sanctions regime is structured in a way and by reference to tests that clearly serve a legitimate, indeed a thoroughly important purpose. The judgment at paragraph 81 correctly records that there was no challenge to this aspect, and there is no challenge to this aspect now. But we have gone through those references in a little more detail than simply to say noted, because it is obvious that the mere fact that they are not challenged doesn't mean that they are magicked away or are diminished in terms of their importance to the overall proportionality analysis. The importance of the objective pursued plainly does feed in a strong and material way to that proportionality analysis. Indeed, we submit it's a core element of it. It is to be recognised just how important those objectives are and the weight to be attached to them, because, as I said, anything that can realistically help to fulfil them or contribute to their fulfilment is important, and that sits on the other side of the equation, in effect, to the impact on those who are subject to the designation. That's what we say about the first of the four bank manner tests. Secondly, rational connection to the legitimate aims. We've dealt with that in some considerable detail in our skeleton before this court at paragraphs 37 to 56, and you will recall that the judgment deals with them in some considerable detail as well, between paragraphs 106 and 128. The 8 factors relied upon by Mr. Reed are set out in the judgment of paragraph 94. 2 initial points on that. Firstly, I've already dealt with respect, and the respect that is to be accorded here is obvious and considerable given the nature of the issues in each of the respects accorded correctly by the judge in this part of his analysis, where what he effectively did was to say, I'm going to consider under each of the rational connections the extent to which this is an issue which engages the need to accord respect. Does it involve a predicted judgment? Does it involve the decisions about foreign policy levers or how Russia might or might not react and so on? And for those reasons, he correctly concludes that considerable respect is to be accorded, and I respectfully submit that was an entirely proper approach for him to take. Secondly, this is about rational connection. And it's only about rational connection. We are allowed to use that word in this context because that's the nature of the test. Rational connection it is. That means effectively capable of having an impact or leading to action or reaction. It's a low threshold. And my fundamental submission is that the judge was entitled and or correct to reach the conclusions he did after the most careful consideration of each of the 8 points relied upon by the Secretary of State for the purpose of demonstrating rational connection to the legitimate aims. We've dealt with the criticisms of that reasoning in some detail in the skeleton. For this court, see in particular paragraph 44. So I take just a couple of examples in relation to this, just to pick up. Firstly, in respect of the suggestion that the claimant's designation will or might incentivise Abramovich to engage and seek to influence the Russian government's actions in Ukraine, or to distance himself from and thereby increase the isolation of President Putin, to speak out against the engagement or the invasion. We've dealt with that in our skeleton at 45 to 47. The evidence, including material on which the claimant himself relies, clearly, we respectfully submit, establishes the existence of a relationship of trust and confidence between Abramovich and President Putin. See, for that purpose, read 2, paragraphs 28 to 31, supplemental bundle, tab 14, page 333. And in effect, what Mr. Shvidler does is to disagree or take issue with the Secretary of State's assessment of the extent to which Mr. Abramovich may be willing or able to influence the government of Russia's conduct. But that goes nowhere near establishing that there is no rational connection. So we respectfully submit that there is every reason to suppose that that channel remains a channel which is capable of delivering results. So far as sending a signal is concerned, that was dealt with by the judge at paragraphs 121 to 122. It was the 5th factor. And so far as that is concerned, the criticism that my learned friend sought to make, I think, was that this was, the judge really focused on the past rather than the future potential effect of that. And my respectful answer to that is he did no such thing. The judge's reasoning in particular is to be found in 122 of the judgment, and it's evident that he was thinking about and concluding that this was designed to influence his and others' behaviour, that's Mr. Shvidler's and others' behaviour going forward, sending this signal. So it was future-facing, even if unsurprisingly, based on past matters. The final example, perhaps, is the 4th of the factors, the speaking out against, publicly or privately, and that is dealt with in relation to Mr. Shvidler's concerns that might expose him and so on. That is dealt with and reacted to as part of the process in Read 2, see in particular paragraphs 35 or paragraph 35C. The objection made orally was, well, the government hasn't engaged to tell him what they think he should do, and the short answer to that is it's essentially a matter for him. It isn't for us to tell him or to seek to prescribe or even facilitate how he might do so. And indeed it might be limiting or potentially even problematic to seek to go down that road. That doesn't demonstrate that there isn't a perfectly rational connection between the measure and the objective, and that possibility remains open. I wanted to pick up one point about what might be described as the various judges, because it was common both to Mr. Justice Garnham and Mr. Justice Sir Ross Cranston and Mr. Justice Johnson, as you saw from 134, this point about cumulative effect and viewing rational connection in the round. The point that was being made by the judges, I respectfully submit, is that you do not have to demonstrate that any one decision, or prove or establish by evidence that any one decision would or have the desired foreign policy outcome. That's the way it was put in the judgment of Mr. Justice Garnham at 136, citing Sir Ross Cranston at paragraph 86 of Sir Ross's judgment. But you can't overstate that point. It's simply a point that says you don't have to show that on its own it would move the decision maker, and that what really needs to happen and what you can and should legitimately do is to take into account the cumulative picture. See Mr. Justice Garnham's judgment at 137, where that point is made entirely clear and its limitation. It is self-evidently not a finding or an approach that says it doesn't matter if you can conclude that it would have no effect. That's not the point that's being made. What has to be shown is the rational connection to the objective, and so in effect that it might contribute. And the judge went through that in painstaking detail under that head. So this is really a straw man point. Less intrusive measures, that's the third of the matters dealt with in the judgment at 131. We've already debated that to some degree. The reference at least to reasonableness, I kept making the point, I'll give you the references under this head. Bank Mellat, paragraph 75, per Lord Reed. Carlisle, paragraph 34, per Lord Sumption, the references to reasonableness. And this is ultimately a question of judgment for the expertise of the decision maker. And we do emphasise, and again this was something that was thrashed out when these tests were being thought through, but is now well established, you need to bear in mind the relevant question under less intrusive measures, which emphasises just how much there matters for the judgment of the decision maker. The question is not, is there objectively a less intrusive measure, full stop. The question is there a less intrusive measure which will achieve the aim as effectively? That's the way it was put, particularly in paragraph 32 of, I think it was Lord Sumption's speech in Carlisle, but it stemmed from an analysis of Lord Reed, I think in the Lumsden case all those years ago, but it's got that relative element built into it. Will it achieve, even if it is less intrusive, you can't just say, well, it could have taken my plane. The question is, would it be as effective if you were only to take the plane? So what that identification of the correct question does is to illustrate the extent to which judgment is involved. That's all I want to say about less intrusive measures. I would submit the judge perfectly entitled and correct to reach the conclusion that he did in his judgment on that point. Fair balance, then, as the last of the elements, dealt with in the judgment at 132 to 145, and it's clear that the Secretary of State, including obviously Coltona officials within that, had clear regard to and weighed the possibility, potentially serious impact on the claimant, but concluded, having regard to the fact of involvement and the importance of the aims being pursued, that the designation was appropriate, did strike that fair balance. And of course, fair balance brings with it all of the elements that one has been thinking about under the earlier limbs to some extent, because you are considering the importance of the objective, the extent to which rational connection may or may not have been demonstrated, the ways in which it might influence the achievement of the objectives, and all of that. So it's all being weighed, so you get the same degree of margin in relation to fair balance necessarily, because those elements are introduced. And indeed, in striking the balance, you get that too, as the authority makes clear. And it's evident that both the judge and the Secretary of State took fully into account the severity of the impact on Mr. Shvidler and his family. We've already touched on some elements of that. The only area that was particularly focused on by my learned friend, in addition to licensing and all of that, which I made submissions about yesterday, is this point about the passport and whether or not it was realised that Mr. Shvidler would be more adversely affected because he was unusually a UK citizen. The effect of that was to create a worldwide asset freeze, as it were. That is dealt with and acknowledged in Mr. Reed's first statement at paragraph 75, supplemental bundle tab 10, page 215, and we're all agreed that that evidence can properly be taken into account and was part of the decision-making process that was engaged in, including the review of the evidence that Mr. Shvidler himself adduced. But nevertheless, it was concluded that despite that impact, a fair balance had been struck between the claimant's rights in effect and the broader interests involved. Read 1, paras 74 to 86 is the evidential source material in relation to that, and explains what the thinking was and how all of that dealt with, and also deals in the earlier paragraph, slightly earlier paragraph 69 to 70, with less intrusive measures, which again feeds into this. The judge's analysis, I say, is at 132 to 145, and he considered, see especially 139 to 141, and properly took into account the severity of the impact. The points that the judge made were that on his or the family's side of the scale, these measures do not and did not, as they did in Belmarsh, for example, touch or threaten either his life or liberty, 141 of the judgment. He made the point that the effects of the designation were temporary and reversible, 141, and I respectfully submit that he was perfectly entitled to draw that conclusion. In particular, it's evident that that conclusion, in effect, drew a contrast between asset freeze measures on the one hand and, for example, confiscation on the others, on the other side, which would obviously raise issues of a fundamentally different type, because they would be, to confiscate, they would be not temporary and not reversible. In any event, in relation to temporary and reversible, we saw from the statutory scheme that there is no bar apart from demonstrating that some new significant matter has arisen. There is no bar to challenge at any time seeking variation or revocation if that is appropriate, and you can challenge the original decision anyway before the court. And the significance of that inbuilt process of challenge and review to the proportionality and the fair balance exercise is, we respectfully submit, supported by the European authority to which he took you as in the Commission. I'm not going to go back to it, but you find the relevant paragraph at paragraph 209 of ES Authorities, tab 48, page 2192. And that case and its reasoning, in other words, acknowledging the significance of those features, temporary and reversible, is not restricted to the mere fact that in that case it was 1 year and reviewable. That's evident both in principle, because in both contexts, however you set up that part of it, it isn't permanent, it isn't like confiscation, and because in heirs, as in other contexts in which these sorts of measures have been applied at the EU level, the 1 yearly thing is routinely renewed. I think in Mr. Ez's case it was renewed 8 or 9 times. But in principle, the description temporary and reversible with the inbuilt opportunity to challenge and to raise developments, and the contrast with confiscation remains. Still on the family side of the scale, the judge placed reliance at 142 on the licensing arrangements and the possibility for those to mitigate the effects. I went through that set of facts yesterday and I don't repeat them. It's clear that he doesn't have any day-to-day difficulty. Paragraph 77, I think it was, of his first statement, that's Mr. Shvidler's first statement. It's equally clear that he could have made licensing applications and engaged properly with the Office authorities in relation to a wide range of matters, including, inter alia, the children's school fees. That's that side of the scale which the judge took into account. On the other side, it's obvious, as the judge found at paragraph 138 accurately, the foreign policy objectives, as he put it, are of the highest order and weigh heavily in the scales when determining fair balance. I respectfully submit that's an entirely correct conclusion. By the time you get to fair balance, he has already concluded, the judge, that there is a rational connection in almost all of the ways in which the point was set out in Mr. Reed's statement. So the link between designation and the objective was satisfied to the requisite degree after careful consideration. And I've made my submissions about the cumulative effect. It's the cumulative potential that matters, where all of the measures that are taken under the relevant regime as expanded progressively by Parliament are taken into account, and different strands can contribute, but you don't isolate the strand. You look at them as a weave. That's the point that he makes correctly in 137 of the judgment. And the final point to note, again, as he correctly recognised, the judge, that even in relation to the fair balance position, you are in territory of an evaluative exercise, and therefore some respect is to be accorded. That's all I wanted to say about Shvidler. Can I move to Dalston? So far as the legislative framework is concerned in relation to Dalston, there are perhaps 4 very short features that go back over the territory carefully traversed by my learned friend Mr. Bethel in his opening submissions, but 4 key features of the legislative scheme that we highlight, if I may. But first of all, the 2019 regulations as amended impose a wide range of economic sanctions that go considerably beyond the designation of individuals and entities. And that wide range of economic sanctions is collectively designed to act as a key foreign policy tool for the government to impose pressure on the Russian state. And we note under that head that the sanctions that have been imposed and that are capable of being imposed have escalated in terms of their breadth in response to Russian aggression and continuing aggression towards Ukraine. They have been amended on 20 occasions, I think, and each time there has been a ramping up of the package of potential sanctions that can be imposed to try and achieve that effect, no doubt, in reaction to the continuing Russian action with all its devastating consequences in Ukraine. So the very extensive trade sanctions that can be imposed and the aim and purpose of the 2019 regulations is avowedly not limited simply to those who directly exercise power and influence in Russia. The objectives are in fact much broader than that, and they are addressed for the purpose of the Dalston case in the first witness statement of Mr. Driver, who heads the department's sanctions policy, at paragraphs 49 to 57, supplemental bundle in the Dalston case, tab 3, pages 48 to 51. That's the first point. Second point is that the detention provisions in the 2019 regulations are made pursuant to the powers conferred under section 1 of SAMBA, and there is no dispute as to the varies of the 2019 regulations. You saw all the relevant provisions yesterday, but just to flick through them very quickly to make sure you have them clearly in mind for what follows, can I invite you to take up bundle or tab 1 of the authorities again, just to go through the provisions very quickly so that they're in your head. Page 5, section 1 of SAMLA.
I mean, is this necessary?
It may not be if you're content to take it.
We've looked at it, we know it.
Then I'll leave
There's
it.
plenty of other things we could
Can I
use
just
to
emphasise?
tackle.
Very well. Then can I just emphasise in tab 4, in the regulations themselves, and again, sorry if this is repetitious, but just so you have it, regulation 7, 1A, sorry, that's in SAMLA, section 7, 1A, and section 8.
In SAMLA,
In SAMLA, I'm so sorry. Yeah.
page 17.
I was jumping ahead. It's really sub 8. Ships owned, controlled, chartered, or operated, or crewed by, and then these are alternatives, is the point I'm emphasising. Designated persons or persons connected with a prescribed country. So that's the distinction that is drawn. It's explicit in the enabling primary legislation, and that is then reflected in the regulations as we will see. The regulations, as you already know, set out the purpose in regulation 4, and then the ones that we are dealing with, and this is the third of the points to emphasise, are regs 57 C and D, and they draw and express an unambiguous distinction between detaining the ship of a person who is designated on the one hand and detain the ship of an individual who is connected with Russia on the other. So they are directly reflective of that primary legislative enabling power. They're not cumulative conditions, they are separate. There's an or that separates them out. And you see that reflected in 57D, 3A and B on page 166. And just one reference, I don't think you were taken to, just to complete the picture, connected with Russia, which is the core concept relied upon here, in 3B of 57D, that is a defined term in regulation 57 capital I on page 177, sub 5. Includes ordinarily resident in Russia, located in Russia, incorporated in Russia, or otherwise domiciled in Russia. It's also to be noted under this head that the connected with limb that we've just seen is a feature that appears, it's a point the judge noted, it's a feature that appears throughout the 2019 regulations and is used in a series of other contexts in that set of regulations. We've drawn all that together, I hope, helpfully, in case you wanted, or in case you wanted to see it. I mean, it goes to the logic of my own friend's argument, but we've drawn together all the other references where that concept appears in the 2019 regs, not unique to the shipping context, in the skeleton to the High Court. And that is in core bundle, it's the annex to our skeleton in the High Court, core bundle, tab 11, page 159 to 163. So we're dealing with a concept which is, on the one hand, broad, because they involve and apply to a wider category of individuals than those who are designated. That's the significance of connected to. You don't need to satisfy the involved person definition expressly and clearly on the face of the legislation, both regulations and primary. And on the other hand, they're narrower because they're prescribing only certain activities, here the detention of ships. So you're dealing with a bit of both, as it were. And of course, Parliament was very well alive to the potential breadth of connected with, as one sees from, I'll just give you the reference, the explanations given by Mr. Driver in his first statement at paragraphs 42 to 44 and 47, supplemental bundle, pages 46 to 47. The fourth and final point to make on the legislative regime is this, and I'll come, I think Mr. Pobjoy is going to come back to this under the Padfield ground, but just to make this point by way of legislative introduction, there was some suggestion by my friend Mr. Bethel that there is some implicit limitation in regulation 57D, so that it only applies by implication to, I think it was to trade ships or to Russian shipping in some other sense that might exclude super yachts. He based that simply on one descriptive passage in the document dealing with criminal offences behind tab 54 of the authorities bundle, page 2263. And if it turns up again, you'll remember the point. My submission is that is an untenable submission. It's untenable firstly because if Parliament was truly going to draw that distinction, it is inconceivable that it would not have done so expressly. Inconceivable because of the structure and the way in which the legislation is set up on its face, but also inconceivable, not least, because of the difficulty of drawing the line. It's not even clear on my learned friend's submissions precisely where that line is to be drawn. If it's drawing a difficult line between some sort of ships and other sorts of ships, then it's not a very easy line to draw, and that reinforces the point that if Parliament was going to grapple with that, it would have done so expressly. Yet there is no hint of anything like that in the regulations themselves, or indeed in the primary, section 7.8. That's the first point. Second point is that it is not asserted by Mr. Bethel that such a restriction is to be implied into regulation 57D3A. In other words, the bit dealing with designated persons. See page 166 of the authorities bundle. But that, of course, makes the submission even harder, because the implication for which he contends, if it's in as an implication, applies in effect to distinguish between different types of ships. And yet the idea of a ship is common to both A and B. So it's jolly difficult to see how you could imply it into one where the word ship appears, but not into the other where the word ship appears also. Nor is there any force in the suggestion that the various different bits that were introduced by amendment, so 57 capital A and following, till you get to D, which is our relevant one, are in some way, shape or form analytically sequenced, with the earlier letters being more driving, as it were. That is a hopeless submission, because there's nothing remotely, either in the legislative purpose or in the legislative materials, or more importantly, or perhaps most importantly, on the face of the language of the regulations themselves, to suggest that in some way A operates to regulate or control or limit the otherwise broad powers of D. And we do respectfully submit that the judge's reasoning, both in that respect and in the paragraphs that follow, particularly at paragraph 63 through to the end of 65, are self-evidently correct, leaving aside whether or not significant parts and driving reasoning in those paragraphs is even challenged. But we submit that those paragraphs are self-evidently correct as a matter of interpretation or the approach to the legislative scheme. So those are the 4 points I make in relation to the legislative framework in Dalston. Come then to the key decision-making, if I may, and just to very quickly spin through a bit of that key decision-making. And the submission is that, as the judge found, the Secretary of State was alive throughout to the objectives of the legislation and considered in some detail why the detention of the ship was proportionate. The detention was, as you know, reviewed on 3 separate occasions. The first one was the 29th of March. Again, you saw some of this yesterday, so I'm not going to invite you to turn it all up. But if you have the supplemental bundle in Dalston to hand, it may be worth just flicking very quickly so I can highlight various bits from the documents, if I can do that very quickly. So the relevant ministerial submission was dated the 28th of March for this first decision, and that is in the supplemental bundle at page 161. For your note, this decision is addressed, and you'll remember the sequence of driver 1. So driver 1 deals with each of these decisions in sequence, and this bit is dealt with in driver 1, paragraph 72 and following. But the men sub is at page 161, and the points perhaps to draw out are that from the outset it was recognised that the fee was a very valuable asset. It's referred to correctly, I submit, as a super yacht at paragraph 4 of the submission. Paragraph 5 indicates the view that was taken that the relevant connected with criteria were met. There is the evidence summary at Annex C to this submission. That starts at page 170, and it sets out the tests and the reasons for thinking that it was satisfied at this stage. Just to highlight the value of the yacht and the evidence or the knowledge of the nature of the value of that yacht, there was a letter from the NCA. If you just go back to page 158, was a letter from the NCA of the 25th of March, which was relied upon, indicating a 45 million euro value. And the total price, I think, was rather more than that. I think the purchase price was even higher and up into the late 50 millions in terms of euro value. So this was a sizable and extremely valuable super yacht that was being considered for detention. The readout of this first decision is at 179. The Secretary of State has reviewed and is content. That's reviewed the submission I just showed you and has provided the attached signed paperwork. So the Secretary of State is in fact relying on the submission that was made to him and agreeing with it. And there's a reference to the public interest in that readout from the decision, which may be of some interest. Some reliance was placed by Mr. Bethell on statements made by the Secretary of State at the time, and again I'm going to leave much of the law in relation to that and the consequences of that to my learned friend Mr. Pobjoy under ground 4, because it's the stuff of ground 4. But simply to note here that the evidence before the court below, and I think the court already has this point, clearly explained that oligarch in the statements by the Secretary of State was being used in the broader sense of a very wealthy Russian individual, and that was rightly accepted by the judge. We submit at paragraphs 69 and 90 of the judgment. And as regards the reference to connections with Putin, the judge concluded that in effect this was political hyperbole and political messaging, and the relevant references into the evidence in relation to that for the nature and reasons for the actual decision are contained in particular in driver 1, paragraph 89. Just to give that some context, can I just invite you to go back to driver 1, paragraph 89, which is supplemental bundle, page 61 and 62. 62 is 89. And you'll see he refers there to the oligarch point. And I'll come in due course to the reason for concluding, drawing conclusions about his wealth later on, but just for your note, driver 2, paragraph 9, which I think was the paragraph referred to by the Master of the Rolls yesterday. It's at page 101. Not just any person, but that paragraph, and indeed the ones that follow, which provide you with indications as to his wealth generation even on his own limited evidence. And of course he didn't give any statement into these proceedings, but you see what Mr. Driver has to say in, for example, paragraphs 11, 13, and so on. But you'll see that he, the long and the short of it is, he's receiving significant economic benefit, has received significant economic benefit from the Russian state.
Are you or Mr. Pobjoy going to make submissions on the position if it was not political hyperbole, but simply a false statement?
I think Mr. Pobjoy is going to make submissions about that. I'm simply giving you the references at the moment into the evidence to try and so you have that all in one place.
Thank you. Time is short.
Time is short, can I give you one other set of references in relation to this?
I would be happy to have these references in writing at a later stage.
Okay, well I can do them very, very quickly if I may.
Good.
91 and 153 of driver 1. That's about how this doesn't, on the evidence, the reasons were those set out in the submissions. In effect, it's the final sentence of 91 and 153 of driver 1. So that's the 29th of March decision. The 11th of April decision, That's dealt with in Driver 1, paragraphs 95 to 107. A relevant ministerial submission is dated the 8th of April, supplemental bundle, page 211. The detailed rationale for the decision is really that contained in Annex D to that decision, which is on page 218 of the supplemental bundle. That's the key. That's the critical document explaining why it was concluded that he had benefited and continued to benefit from the current Russian regime to accumulate the level of wealth that he had to be able to afford a super yacht, and why it was thought that the detention of that boat would contribute to the achievement of the objectives. So Annex D is really the critical document there, but you might also choose to note that the ministerial submission preceding that April decision next a proposed response to the owner's representatives, and that is at page 217, so we would invite you to read that also. There was then a period of time, which is a third period, if you will, between 11th of April and the 13th of December 2022, and this really goes to a holding decision and whether or not it's properly to be described as a holding decision and whether that affects things. But the position so far as that is concerned, in very brief summary, is this. 26th of May 2022, the DFT receives the promised representations from Sir Ian Collett. Those are at page 224. The central thrust of the representations was that Mr. Naumenko was not a sanctioned person. He was a wealthy businessman with no link to Mr. Putin. Information is provided in that letter as to the sources of his wealth, including, I would note, being one of the shareholders and managers of an investment company called Troika, which you saw reference to in the evidence, which was then sold to the state bank, which is now sanctioned, the Esper Bank. But he also had involvement, see page 232, in a construction company that built a number of government buildings. That material was all considered by officials who took the view that that information did not alter, indeed reinforce the position supporting detention, and that view was set out in a letter of the 14th of June, which is at 241 in the supplemental bundle. Then on the 1st of December 2022, the legal representatives wrote and asked for the detention to be revoked. The decision was taken to conduct a further review and seek ministerial input. That process is then dealt with in Driver 1, paras 115 to 119, supplemental bundle 71 to 72. All of the evidence provided in May was re-reviewed, and the view was taken that it in fact strengthened the department's position, because it confirmed, amongst other things, that Mr. Naumenko was a man of very considerable wealth. He had been involved in a company that was sold to the state. He had been involved in a construction company that was involved in government work, and none of that had been denied. And that then provided the backdrop. If I can just finish this in 30 seconds. That provided the backdrop for the 3rd of January 2023 decision, which is the 4th of the areas. So far as that is concerned, which is perhaps the critical one, led to a ministerial submission of the 13th of December, 292 of the supplemental bundle. Annex C is the critical document in that, at 297 to 298. New information taken into account in preparing that annex, as Mr. Driver's evidence makes clear, and similar themes to earlier, but that document needs to be read in full, I respectfully submit. And then the final readout, reflecting the Secretary of State's decision, is then made on the 3rd of January, and that's recorded in the document at page 312 of the supplemental bundle. My lords, my lady, that leaves me with some pretty short submissions, which I would hope to be able to complete within 15 or 20 minutes of the resumption on proportionality, and then I will hand over to others who will deal with grounds 2 and following.
Well, we're
So I hope
expecting to hear both Mr. Pobjoy and Miss Plews.
you are. There was a little blip last night because Miss Plews is a junior and not on panel counsel, so Attorney General permission has been
got into action.
Attorney General permission. That's the right way of describing an either genuine decision or not, having been told that the decision had to be made. But you will be hearing from Miss Plews as well, I'm delighted to say. So
We're delighted to hear that, but it will have to be brief, unfortunately.
they're going to be, but I'm going to be finished in 15-20 minutes, and we're bearing in mind your picture to try and get done by 3 o'clock.
If you can. Okay, thank you. 2 o'clock.